Good morning. Today's topic is going to be expropriation. We understand with expropriation the taking by state authorities of the property owned by the investor. This apparently simple definition actually hides a very complex concept which has multiple aspects. Indeed, we can distinguish between various types of expropriations and expropriatory acts. On one side, there is direct expropriation, which involves the transfer of title or the outright physical seizure of the property by the state. Direct expropriation, as you will understand, is usually easy to establish as the property has been explicitly taken. On the other hand, there is also indirect expropriation. These are measures that are short of physical taking, but which at the same time impact the investment to such a degree that it is now completely worthless. In other words, an indirect expropriation is an action which, while it is not formally a taking, has effects equivalent to it. To do a very silly example, we have a direct expropriation where I take the chair on which you are sitting. On the other hand, we might have an indirect expropriation where I make a law which prohibits you from sitting on the chair. So, in theory, you still have a chair, but you cannot anymore use it. Finally, there is another third concept, which is the one of police powers. Under customary international law, a state can undertake non-discriminatory general regulatory measures, which will not amount to expropriation and for which the state will not have to pay compensation. The problem is, of course, to distinguish between an indirect expropriation and the legitimate use of police powers. For what concerns expropriation itself, customary international law lays down the requirements for a lawful expropriation. These requirements have been largely followed by all bilateral investment treaties. In order to be lawful, an expropriation has to be for a public purpose, non-discriminatory, it must be made in accordance with due process of law, and it must involve compensation. In the past, there was a lot of controversy, as you will remember, about the quantum of compensation, whether states had to pay compensation to foreigners, to foreign investors upon expropriation. Nowadays, there is a wide consensus on the fact that expropriation must be followed by prompt, effective, and adequate compensation according to the market value of the investment. Nowadays, the problem is rather to distinguish between indirect expropriation and the use of regulatory powers. Indeed, today, states will rarely take explicitly an investment, but they will frequently have to adopt environmental or public health measures which have a negative impact on this investment. So before we go into indirect investment, let's analyze further the customary criteria for a lawful expropriation. For what concerns the public purpose of the expropriation, investment tribunals have given a wide margin of discretion to states in defining their public interest. As long as a state can articulate a legitimate purpose which may warrant it taking action, a tribunal will usually accept as valid its legitimate purpose. Very rarely, investment tribunals have denied the legitimate nature of this public purpose when, for example, the state did not give any evidence, such in ADC versus Hungary, or when the state took action uniquely as a way to punish another state. This is the example of the Libyan expropriation claims in the 1970s. The second criteria is the one of non-discrimination. For what concerns non-discrimination, the simple fact that a foreign investor has been targeted does not constitute per se an evidence of discrimination. You have a discriminatory taking uniquely when the investor has been targeted because it is a foreigner. An example of this is the case of Eureko versus Poland, in which the refusal to renew a share purchase agreement from the Polish government was preceded by xenophobic declarations of the Polish government, in which members of the government promised not to give the Polish insurance sector in the hands of foreigners. So, for what concerns the criteria of public purpose and non-discrimination, there will be usually a high degree of deference by investment tribunals towards the state. The third criteria is the one of due process of law. An expropriation has to obey the relevant criteria and procedural requirements laid down in national law. Moreover, in order for due process to be fulfilled as a condition, the investor must have the opportunity to have his case reviewed by fair proceedings by an impartial and independent court. So this, in addition with the requirement to pay compensation, are the customary criteria for the legality of expropriation. When you have a direct expropriation, it's very easy to verify whether these criteria have been respected. On the other hand, with indirect expropriation, where the state has not explicitly taken the title to property, it will be more difficult to establish whether these criteria have effectively been respected. Before we go into indirect expropriation, we have to answer two other questions. The first is which assets are protected by the rule, by the prohibition on uncompensated expropriation. Well, the easy answer will be any asset covered by the relevant bilateral investment treaty. From the point of view of customary international law, also, the Iran-US Claims Tribunal in Amoco versus Iran said that the protection against unlawful expropriation extends to any kind of asset which can be the object of a financial transaction. In other terms, everything that can be monetized is an asset which could be expropriated and which then deserves protection under the customary prohibition against uncompensated expropriation. The second question is for us to understand which kind of state conduct may amount to expropriation. Here, the case law agrees that only conduct in which the state engages in as a sovereign may constitute expropriation. In other words, only acta iure imperi. On the other hand, situations in which the state acts as a party to a private law contract, so situations in which a state fails to fulfill a private law contract, will not usually be considered to amount to an expropriation. Examples of this holding are the decisions in Azinian versus Mexico and in Waste Management Inc. versus Mexico. So, for what concerns the problem of indirect expropriation, bilateral investment treaties and free trade agreements usually cover not only direct expropriation, but also indirect expropriations. They indeed refer to acts of expropriation or acts amounting to expropriation. Our question here is then to understand firstly, what is an indirect expropriation? So how do we prove the existence of an indirect expropriation where the state didn't explicitly seize the property? And secondly, to know how a distinction can be made between an indirect expropriation and the exercise of police powers, which will not require compensation. For what concerns the first question, investment tribunals have usually retained the criteria of substantial deprivation. The investor, in order to prove that there has been an indirect expropriation, has to bring evidence of substantial deprivation. This means that he has to prove that the actions taken by the government have an effect equivalent to direct expropriation. To put it more simply, he must prove that the action of the government was so negative, had such a heavy-handed impact, that its effects were equivalent to expropriation. In the case of Metalclad versus Mexico, decided under the NAFTA agreement, the tribunal held that expropriation includes not only open and deliberate taking of property, but also covert or incidental interference, which has the effect of depriving the owner, in whole or insignificant part, of the enjoyment of his property. So there is a wide consensus that the notion of expropriation includes not only direct expropriation, but also indirect expropriation. This is evidenced not only by decisions such as Metalclad versus Mexico, but also by numerous investment treaties, which speak not only of expropriation, but also acts equivalent to expropriation, or acts tantamount to expropriation. However, not every single action having a negative impact on the investor or the investment will constitute an indirect expropriation. An example of this is another decision, Pope and Talbot versus Canada, which was made under the NAFTA agreement. Pope and Talbot versus Canada concerned a business which exported timber from Canada to the United States. Canada undertook measures which restricted the export of timber. So the main business of the investor was severely affected. They could not anymore export timber. However, Pope and Talbot remained in control of the operation and could continue its activities, even if it could not export its product to America. In this precise case, the tribunal held that there had not been a substantial deprivation, because the investor remained in control of the relevant facilities, could continue his activities, and derive profits from them, even if its possibility of exporting had been limited. So, substantial deprivation remains if not the most important criterion to understand whether we have an indirect expropriation. However, it is not the only one. Various tribunals have also used the notions of legitimate expectations. The notion of legitimate expectation indicates a specific promise made by the government to the investor, on which the investor can reasonably rely. An example of the use of legitimate expectations in the context of expropriation was the case of TechMed versus Mexico, in which the fact that the government had promised to TechMed that the relevant permits would be issued had a very important role in the decision of the tribunal. Finally, our third criterion is proportionality. Proportionality is a general principle of law which investment tribunals have borrowed from the practice of the European Court of Human Rights. A measure will obey to the test of proportionality when it is proved that it is the least restrictive manner to attain a legitimate objective. Recent tribunals, such as Philip Morris versus Uruguay, have used this criterion in order to distinguish indirect expropriations from the legitimate use of police powers. This leads me to the final part of this lecture, which is the notion of police power exceptions. Under customary international law, a distinction must be made between expropriation, the taking of the property, and the legitimate use of police powers. That is the situation in which general regulations adopted for the public good have a negative impact on investment. In this second case, there will be no duty to pay compensation to the investor. However, as you will see, as you will remember, it is extremely difficult in certain situations to distinguish between indirect expropriation and police powers. An example of this, to which we referred in our first lecture, is the case of Vattenfall versus Germany. Does a prohibition on the use and the production of nuclear power amount to an indirect expropriation? In this regard, the most quoted case concerning police powers is the one of Metanex versus United States of America, another NAFTA decision. This case concerned the prohibition by the government of California of a methanol-related chemical, which was found to have negative environmental effects. Metanex business was precisely the production of this chemical, and so this general prohibition put an end to its activities in California, which had suddenly become prohibited by law. So Metanex argued that there had been substantial deprivation and that this was an indirect expropriation. However, the tribunal disagreed with the claimant, holding that, and here I quote again, as a matter of general international law, a non-discriminatory regulation for a public purpose, which is enacted in accordance with due process and which affects a foreign investment, is not expropriatory and compensable unless specific commitments have been given by the government to the investor. So here you see that a general measure which is non-discriminatory and which is adopted for the public purpose will not be an expropriation, even if it affects inter alia a foreign investor. You will also notice that here the tribunal referred explicitly to the requirement of legitimate expectations. So, unless there will be a specific representation made to this investor that such a measure will not be adopted, a general measure, which is not discriminatory, will not be deemed to be an expropriation. This idea of police powers has now entered the mainstream of investment treaty arbitration. The holding of Metanex versus USA was upheld and quoted by successive tribunals, such as Saluka Investments versus Czech Republic and Philip Morris versus Uruguay. An helpful role for states, the police powers exception has some logical inconsistencies. The former British ICJ judge, Rosalind Higgins, observed that the police powers exception is a paradox. Indeed, the police powers exception says that measures adopted for a legitimate purpose will not amount to expropriation. However, at the same time, the customary norms on expropriation say that expropriation has to be for a public purpose. For this, Judge Higgins concludes that it is in reality impossible to come out with rigid and functioning criteria to distinguish between indirect expropriation and the exercise of police powers. Investment tribunals are indeed still struggling to find this definition. So this will be all for today. I thank you for your attention, and I invite you to look out for more at the relevant section online. Thank you very much.